Hi, folks. It's Andy Stautz here with Stautz Law. I am back for another talk about Indiana estate planning and probate. Today, we're going to be a little bit funny. The title of the talk is Things That Don't Matter. And this is just kind of a talk that came to me when I was thinking about some of the things that people will say, my clients, other heirs, potential clients, when they're talking about an inheritance or a probate matter. So it's kind of like myth busting, right? So, number one thing that doesn't matter: who's the oldest child? Okay, a lot of times someone will come to me and they'll say, "Well, I'm not the oldest, but I'm the responsible one, and I should be personal representative." Or my older sister says such and such, and she's right, or whatever. Okay. Indiana law, Indiana probate law, the intestate laws of succession don't care about birth order. It does not matter if you're the oldest or not the oldest, in general. Okay. So there are weird exceptions. If someone writes in their will, my oldest child shall be the personal representative, then okay, it matters. But in general and overall, this isn't medieval England. We don't have primogeniture. Like, birth order doesn't matter. All siblings are treated equally if they're, by the same parents, etc. Okay, so that's one thing. Second thing, does not matter who holds the paper deed. Okay, I just recorded a talk about whether you need a paper deed at all. In most cases, and again, things can get weird, so not every time, but usually having the actual paper copy of the deed doesn't matter. Okay, so just because one sibling has it and the other one doesn't, or because it was lost, or, it just, physical possession of a deed usually and in general doesn't change what's in the property records. Okay. All right, so that's some more good things. What else do people talk about mattering that doesn't matter? Verbally expressed last wishes. Again, in general, I think I've talked about non-cupative wills at some point, and people are complicated and they do complicated things. So not always, but in general, last wishes that aren't reduced to writing, that aren't, actual estate planning documents, aren't going to work. And that cuts both ways, right? Sometimes you've got someone who says, "Oh, I want you to have everything." Other times they say, "Oh, I want Bobby to have everything." It's like, well, there are moral claims, but in general and overall, I'm just a lawyer. All I can do is follow the rules, and for the most part, the rules don't have a lot to say about verbal last wishes, promises, and stuff like that. That's obviously very complicated. So that's kind of three examples: birth order, physical possession of deeds, and documents in general, right? We've talked about in the past about how to get a paper copy of a will. The contents of a will aren't supposed to change based on who's got it in the drawer. And then the other one would be, verbal last wishes. So those are just some common things that I see from time to time. Moral of the story, I think, is people's ideas about how probate and inheritance law works doesn't necessarily line up with what the law is. So if you're talking to an attorney, you should be honest and give them the full story. That way you can get, correct advice. And in general, just because someone says something about the law or because you've got some idea doesn't mean it's so. So you need to,